Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is courtroom 304. This is August 26th. I'm sorry, to August 27th of 2024. This is the jail calendar and the arraignment calendar. I'm going to call the arraignment calendar first. And then once we have resolved those cases, we'll move to the jail calendar. First case on the arraignment calendar.
Your Honor?
Yes.
My apologies. I was expecting you to be here in the courtroom. I'm logging in now.
Okay. All right.
All right.
So let's just give the courtroom a minute to look.
a minute to look.
I appreciate you. Not helping me, but helping me get the right out. All right, Your Honor, we're good.
All right. Good morning. All right. So this is the jail and arraignment calendar for Tuesday, August 27th. I'm Judge Tammy Long Hayward. I'm going to go to the arraignment calendar first. First name on the arraignment calendar is Kyle Naja Durrell Hatton. Kyle.
Here, Your Honor. Here, Your Honor.
All right. Well, sir, it'd be easier if I had your name on the screen instead of Kyung's phone.
I'm sorry, man. I'm not really good with all this. This is my first time on Zoom, so I don't really know how to use it or anything like that.
Hold on.
I don't even know how to turn on my camera.
All right. Mr. Hatton, you're before the court for a seatbelt violation, invalid registration and no tag, or expired or invalid tag. You have the opportunity, sir, to either have an attorney represent you or to represent yourself. And if you represent yourself, if you wish to hear from the state about what they're asking for on those offenses, then we could do that.
Man, I would rather represent myself, but I have a question, Your Honor. This case is like about 6 years old, and I haven't had that car in years. And when I got served the citation, I've never had a court date scheduled or whatnot until last year, which I was still unaware of. I got a new car now, have registration and everything
All
on
right,
this car.
Ms. Hagler.
Your Honor, if the state can show me proof of what he has for the new car, then the state would dismiss, don't have a problem dismissing this case. So if he can just, we can pre-try. I can pre-try
Okay.
right now.
So,
Mhm.
hold on, Mr. Mitchell, hold on, everybody. It works a lot better if you just wait until I call your name, okay? And then we can talk about your case individually. Even if you have the same situation, we'll do the same thing for you. So, Mr. Hatton, what I'm going to do is put you in a breakout room with the state. And if you
Yes,
can
ma'am.
show them your registration, then she's willing to dismiss. But you got to figure out your camera first. So I'm going to send you a prompt to start video. Did you see something come up on your screen?
Yes, ma'am.
All right, if you click on that, that might help. There you go. All right, so what I'll do is I'll put you in a breakout room with the state in a moment, and then you all can talk about your case, okay?
Thank you,
All
Judge.
right, thank you, ma'am.
All right, so just hold on for me. If you will, Mr. Hatton, if you will mute your device, what that means is you're looking for something that looks like an old-fashioned microphone on the screen. If you don't see that, then click on where you see yourself, and then a box with 3 dots should come up, and just press mute, okay? All right. All right. So next person on the calendar, the arraignment calendar, is Carlton Mitchell. Mr. Mitchell, you are before the court for possession of marijuana 1 ounce or less, possession of a drug object, and traffic violation.
Yes, ma'am.
All right.
Yes, ma'am.
Did you wish to speak with the state, or did you wish to have an attorney represent you?
Your Honor, the calendar says Lister and Holt, so I believe he already is
Oh,
represented.
I'm sorry. You are correct. Mr. Lynch?
Yes, Judge, I was not able to speak to Mr. Mitchell. I think our number was expired. I also do not have the offer from the state. So it might, if perhaps she could either send that to me, and then I could just do a breakout room with Mr. Mitchell, or I could.
All right. So, Mr. Mitchell, what I'm going to ask you to do is, do you know how to use the chat function?
Yes.
All right. If you will chat your phone number and email address to the courtroom 304. Don't send it to everybody. When you see the name in blue that says everyone, click on that. It'll have a pull down menu, and you'll see courtroom 304. Send it to courtroom 304. And Mr. Lynch is going to communicate with you by phone if he can't, like we'll do a breakout room or phone, okay?
Yes, ma'am. You said phone number and what else?
Email address.
Email address. Okay.
Yeah.
And Attorney Lynch, I will send the offer to Attorney Taylor.
Okay, you're gonna send it via email?
Yeah, she's sending it on the line that he has on.
Yes, because I don't, yes. Thank you, Judge.
Perfect.
Thank you. All right, so Rodney Wayne Smith, criminal trespass.
Judge, Mr. Smith is here.
All right.
Can I leave it? Excuse me, Your Honor.
Yes, Mr. Mitchell.
I mean, I sent the phone number and email address.
I see. I'm gonna call you in about 5
He's
minutes.
gonna call you in a few minutes. I'm gonna mute you. You'll be able to hear us, but we won't hear you, okay?
Okay, I'm currently at work right now. That's why I was asking.
Okay, he's gonna call you, and you can
Okay.
just step out and take the call, all right?
All right, thank you.
All right. If you get disconnected, just come right back on. We're not gonna penalize you for that, all right?
All right.
All right, thank you. All right, next case on the calendar is Lisa Walsh. That's Lister Holton Dennis.
Judge, I believe Ms. Walsh is in custody, and
Your Honor, she.
All right.
I'm gonna send you a message, Your Honor.
Okay.
Her case have to be continued.
All right.
and
All right.
Judge, Mr. Smith is ready to enter the plea whenever you're ready to entertain that.
I'm ready. Mr. Smith. One second. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So, Mr. Smith, you're before the court on 2021 CR 08112, Rodney Smith. Okay, so medical continuance for Miss Walsh. So Miss Wright, Miss Val, medical continuance. All right. Thank you, Deputy. Yeah, thank you for that. So you're before the court for criminal trespass. Mr. Lynch, what is your client plead to the offense of criminal trespass?
No, Your Honor.
All right, by entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Judge, you were frozen for a minute, so he probably didn't hear every right that you went over. I do apologize for that.
No problem. So you have the right to, you've given up the right to have a trial. You've given up the right to present evidence and testimony during the trial. You're giving up the right to be considered innocent. You're giving up the right to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Did you understand all of those, sir?
Yes, ma'am.
All right, thank you. Factual basis and recommendation, please.
Yes, Your Honor. On or about October 24th of 2021, Officer E as in Edward Grayman, G as in girl, AYMAN responded to 8521 Cedar Creek Ridge, Riverdale, Georgia 30274, Clayton County, Georgia, in reference to a domestic disturbance. Based on the warrant in the packet, the defendant took the victim's purse. Victim's name is Camille, Camille, Belgrave, B as in boy, ELGRA, V as in Victor E. Took her purse for approximately 20 minutes. The defendant did admit to taking her purse and placing it in the trunk of his car in order to get the victim mad. The defendant stated that the victim allegedly took his inhaler. Both the defendant and the victim were living at the same residence. So this is what makes the crime criminal trespass, family violence. At this time, the state was recommending 12 months to serve, 4 days, balance suspended, and to have no contact with the victim, Camille, CAMILLE, Belgrave, B as in boy, EL, G as in girl, RA, V as in Victor, E.
All right, Mr. Lynch.
Yes, Your Honor, that was our understanding. We're just going to ask the court to accept that plea. He doesn't have any issue with the no contact provision. And we just ask the court to accept the no-low plea and accept the recommendation of the state.
All right, so Mr. Smith, talking is always better. Her taking your inhaler, you know, I have asthmatics in my family. That's a scary proposition. And you taking her purse, that, you know, that's not a good communication style. So even though you're going to have no contact with Miss Belgrave, just remember for the next relationship, sir, that talking or walking away are the better options. Okay. All right. So I'm going to accept your plea of nolo. I'll sentence you to 12 months to serve 4 days, credit for time served. The balance will be suspended as long as you have no contact with Camille Belgrave or have any new violations of the laws of the state of Georgia. All right. You're free to go at this time, sir.
Thank you, ma'am.
You're welcome. All right. So Walsh is continued. Smith has taken a plea. Mitchell and Hatton need breakout room. So I'll put Mr. Hatton in a breakout room with the courtroom and Mr. Mitchell in a breakout room with the courtroom and Mr. Hatton in a breakout room with Ms. Hagler, the state.
Thank you, Judge.
All right. All right, Mr. Hatton, you should have gotten your invitation to the breakout room. I'm sorry, Mr. Mitchell, Mr. Hatton, you're getting your invitation to the breakout room. All right, hope I got that right. Yes. All right, and they'll be back in a moment, ladies and gentlemen.
Your Honor, I do have an announcement slash a question for the court on Mr. Carlton Mitchell.
Yes, sir.
Judge, Mr. Mitchell does want to resolve his case here pursuant to the offer. However, court whether he can plead to count 2 under the conditional discharge statute. He does drive for a living, and I believe he can use that. Possession of drug-related object, the conditional discharge statute would still apply there. And so we would ask whether the court would grant him a conditional discharge for a plea to count 2.
Does the state object?
I'm not sure.
Well, when she comes back, let's ask her, because if she doesn't object, I'm fine with it.
Thank you, Your Honor. You have to apologize. I didn't mean to say.
And that's the appropriate.
Yeah. Ms. Hayward?
Yes, yes.
While you were in the breakout room, I had made an announcement that Mr. Carlton does want to go ahead and plead pursuant to the state's offer. However, we're asking the court to accept his plea to count 2 under the conditional discharge statute. Judge Hayward said she was okay with that. She wanted to see if you were going to object or not.
Oh, the drug related?
Yes.
Let me see. He doesn't have much of a record, so let me see.
Right. Yeah, I don't believe he has any record. That's at least as far as those category of charges. That's why he would be eligible for that, I believe.
Here's a DUI. That was 2021. right, let me, go back to the statute. And if there's no issues, then yeah, I won't object. Let me go back to the statute. Give me one.
Thank
Mhm.
She said, let me go back to the statute. Oh, I'm not.
So, we can do a breakout room, Attorney Lance. So let me try to put some, let me see, Miss, where is she? I didn't do a breakout room. Ms. Powell or Ms. Val, can one of you put me and Attorney Lynch in a breakout room, please?
Attorney Hagler, I'm not a host. So I'm
Oh,
unable
okay. Okay, gotcha. Okay, that's fine. Okay, thank you. But that's fine. So I'm looking at your client's history, and I see that there was an incident, May 30th of 2021 in another county, for marijuana less than an ounce. I need to actually find out the disposition, because it says time expired, so I don't know what the outcome was. So we can probably just reset for a few days so I can, get my investigator and find out exactly what the outcome was. Because other than that, he may not qualify for the discharge if he already has a previous conviction.
Okay, I understand what you're saying.
Yeah, so this is May 30th of 2021, and it's showing from Roswell.
Okay,
I can see exactly what the outcome was. So we can definitely reset it or have her scheduled for the jury trial calendar. I definitely have an answer by then, probably before the end.
can I be actually placed back in a breakout room with Mr. Mitchell to kind of let him know about that and see whether he wants to just resolve or whether he wants to have it continued for you to verify that what that resolution was, and I may be able to find out from him either way,
Okay. You should be able to go back to that breakout room. If you click probably the little dots on the bottom, you probably can go back. Do you remember which one y'all were in? Because you could probably go back to that one.
If it's
Because I think no one else on here is a co-host but Judge Hayward. So
Are we ready on Hatton and Mitchell?
Your Honor, yes, I do have an announcement. The state is going to non-pros Mr. Hatton's case based on the information he provided. And we're
All right.
Mhm.
Mr. Hatton, you're free to go at this time. Please be safe, sir. Thank you.
Thank you. Y'all have a great evening, morning.
You
You too.
too. All right, and we're ready on Mitchell.
Your Honor, Attorney Lynch is speaking to his client.
Okay, no problem.
Yes.
All right, thank you.
Mhm. Hold on, let me.
Your Honor, I do have an announcement as far as Mr. Mitchell's case. He should be joining us. Judge, Mr. Mitchell determined that he would rather enter pleas of nolo to both counts pursuant to the state's offer rather than he may or may not be eligible for the conditional discharge. So he wanted to just go ahead and plead nolo to
All
count
right. All right, Mr. Mitchell, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down, sir. All right, sir, you're before the court on State of Georgia versus Carlton S. Mitchell, 2021 CR 08106 for marijuana 1 ounce or less, possession of a drug-related object, and traffic violation. Mr. Lynch, how did your client plead to the offenses before the court?
He asked the court to accept no contest pleas as to count 2 and 3. Count 1 would be null pros pursuant to the plea agreement, from my understanding.
All right, by internal plea of nolo to counts 2 and 3, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Mitchell?
Yes.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about October the 2nd of 2021, Officer D as in David Watts, Watts, observed the defendant at the intersection of Highway 138 and Terra Boulevard, Clayton County, Georgia. The defendant ran a traffic light or a red light. At that time, Officer Watts conducted a traffic stop. Upon making contact, Officer Watts observed a marijuana rolling tray in the passenger side door. The defendant was asked if there was any drugs in the car, in which he replied yes. The defendant advised there was marijuana inside of a medicine bottle under his driver's seat. At that time, the defendant was removed from the vehicle and detained. The suspected marijuana in the medicine bottle was weighed at 1.06 grams. During the vehicle inventory, officer did locate drug-related objects. During that time, Your Honor, at this time, the state is going to now prosecute count 1. Count 2, a fine of $300, and count 3, a fine of $100.
All right, the $300 fine, sir, is going to be $444 and $444. I'm sorry, and that'll be count 2. On count 3, it's a $100 fine. That'll be $151.50 with the surcharges. Do you need more than 60 days in which to pay those?
No.
All right, so I'm going to grant you 60 days. Counts 2 and 3 will run concurrent. Count 1 is a no pros. Sir, you hold a big responsibility. If you drive commercially, please make sure that this is not a part of what happens when you're on the road. We're clear?
Yes, ma'am. That was before I got a commercial driver job.
Yeah, it was before. Okay. Because I see the date, but you understand what an awesome responsibility that you have with that vehicle. And so I just ask that you exercise safely. All right, you're free to, Mr. Lynch, do you have his email address?
I believe you put it in the chat previously.
Okay, if you have it, can you send that to Ms. Wright?
Yes. Through the chat? Or...
Yeah, through chat.
Okay, I sent it.
All right, thank you. All right, Mr. Mitchell, you're free to go at this time. Please make sure that you pay within 60 days. It'll come to your email address, and there'll be instructions about how to pay online or by phone if you choose to pay that way.
Okay, thank you.
All righty. All right, ladies and gentlemen, this is the jail calendar for August 27th of 2024. These are jail and probation cases. First name on the calendar is Tazay Benjamin Boykin. Tazay Benjamin Boykin.
Your Honor, the defendant should be detained. This is a motion to revoke his bond, and I believe my officer is on, so we're ready to proceed forward on this motion.
All right, Mr. Lynch, Mr. Taylor.
I believe Mr. Taylor has it.
All right.
No, he can come up. Your Honor, we had intended to enter a plea today. Actually, previously, Mr. Boykin was on your calendar, and you rejected his negotiated plea at that time. He has since served an additional, I think at this point, he's been in custody for 49 days, plus any time that he served prior to bonding out initially on this charge. And we would like to enter a plea today if the judge is willing to accept the 49 to 50 days that he's been in custody. The original offer was 12 months to serve 10 days from the solicitor.
All right. I can double check, Your Honor, to make that amount of time.
And is there an outstanding case or another case?
My understanding is
Yes.
There's an outstanding case that he has not posted on bond on, so he will still be in custody following conclusion of today's, regardless of resolution.
All right, Ms.
Some research, see if there is a court date for that other case. I can do some research, a few minutes to do that.
Yeah, do you all have an objection to him resolving this first one?
The state, no, Your Honor, I do not.
Okay,
I think
all
the
right,
amount of days he's been in.
bring him in.
Give me 1 second, Your Honor, while I do that research.
Yes, ma'am.
Thank you. Let's see. I'm only showing 10 days. Where are you getting 40 from?
He's been in custody since July 9th.
Okay. This is August.
So
Okay.
the 10 days would be the original arrest and bonding out. So his total in custody at this point in time would be approaching 59 or 60 days.
Okay, you said July. Okay. Okay. And then, Your Honor, if I can have, did you still want me to do the research to see exactly if the other case does have a court date coming up? Oh, did she? No, no. Okay. Let's see.
Mr. Taylor, y'all ready?
Yes, Your Honor.
One moment, Your Honor.
Okay.
Yes, Your Honor, we're ready to proceed now.
All right, Mr. Boykin,
Yes,
raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. You're before the court on 2022 CR 07029 for Tizay Benjamin Boykin for simple assault count 1, firearms discharge count 2, and reckless conduct count 3. You're represented by the law firm of Lister Holton Dennis. Mr. Taz Taylor is with you. You were before the court pending a motion to revoke bond. However, you're taking a plea and going forward with a plea. By entering a plea, what does your client plead to the offenses before the court, Mr. Taylor?
Your Honor, my client pleads guilty to the 3 charges before the court.
All right, by entering a plea of guilty to counts 1, 2, and 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about June 15th of 2021, based on the warrants in the packet, the defendant got into a verbal altercation with his live-in girlfriend at that time, Alexis, Alexis, last name Dorsey, D as in David, Orsey. The victim's sister, Kanisha, Kaneis as in Sam, H.A. Dorsey, traveled over to the defendant's home to remove her from the location to avoid the defendant. Ms. Kanisha advised that while she and her sister, Alexis, were walking to the incident location, the defendant followed them and discharged a 9mm firearm in the air numerous times. Ms. Kanisha stated that she reacted by discharging her pistol back in the, her pistol back in the area of the offender to protect herself and her sister, Alexis. During Officer L. Covington's investigation, he did collect 12 9mm shell casings from the roadway of the incident location. Also 9mm bullets were recovered from the incident location as well. Your Honor, at this time, the state's recommendation is going to be 12 months to serve 90 days. Balance probated. The defendant is to go to a gun safety course and to forfeit his weapon.
Okay, and this is concurrent to all 3.
Yes, Your Honor. The defendant can receive credit for time served if he served 59 or 60, but the state is requesting 90 days.
Okay. All right, Mr. Taylor.
Your Honor, after speaking with my client, we decline that offer. We'll stand by our not guilty.
You all can go non-negotiated.
Yes, we are, and we're standing on our not guilty.
Okay.
All right. So, Mr. Boykin, not guilty. We'll see you on your trial date. And also, my understanding is there's another case pending. If you're going to go not guilty on both of those, we'll do our best to try them as close in time as possible, if not on the, during the same trial week. All right. You can go back with the sheriff's office.
And Your Honor, since the state, I guess our position would be, since the defense is not moving forward with the plea, again, Officer Moore is on. The main purpose of today's calendar was to revoke the defendant's bond. And so we're ready to proceed forward on the motion to revoke bond.
All right, Mr. Boykin, come on back.
Your Honor, we've changed our position in the matter. We will accept the state's recommended sentence of 90 days rather than the 60 that we thought we were receiving. We'd like to go forward with the plea.
All right, so the court is going to impose on counts 1, 2, and 3, 12 months to serve 90 days to run concurrent for each of the counts. Balance will be probated for Mr. Boykin to take a gun safety course, and he's to forfeit the weapon and not have any other firearms in his possession until he has been certified as having taken the gun safety course.
Understand? No firearms until you take them.
All right, Mr. Boykin, my concern with this case is, sir, y'all were in the middle of the street having an OK Corral shootout when you don't understand that bullets have to go somewhere. When you shoot a bullet up in the air, do you understand that it's coming down somewhere? And it may not come down where you intended in the ground. It may come down on the top of someone's head. Had a case about 4 years ago where a woman shot into the air trying to break up a fight in her front yard, and she ended up killing her own son because the bullet came down on his head. So, sir, when you out there just throwing bullets at each other like y'all don't have no good common sense, y'all are liable to kill somebody and not the person you intended to aim at. You shooting in the air, she shooting at you. Y'all acting like y'all don't have like y'all don't. Crazy. It's just crazy. It's just crazy. First of all, people act like they don't understand that guns can kill folk, and I am a major proponent of gun safety. If you're gonna have a gun, have it secured safety, operated safety, know what it can do and know what it's not supposed to do. Y'all picking up guns like it's the OK Corral out here, just shooting at each other, just crazy. What about contact provisions? Because Miss Alexis Dorsey and Kanisha Dorsey.
Yes, Your Honor. I know that on the previous bond order, the defendant was told to stay away. We just ended up picking up that new case.
Then you'll stay. Then the court will renew its renew its order that you stay away from Miss Kanisha Dorsey and that you have no contact with Miss Alexis Dorsey. Because as one of my friends says, y'all don't have good common sense. All right, you can go back with the sheriff's officer.
Thank you, Judge.
All right, next on the calendar is Caffey. Mr. Caffey has 3 cases.
And then, Your Honor, before you move on, may Officer Moore be excused? He was here for the motion. Okay, Thank you, Officer Moore. Have a good day.
Thank you, sir.
Your Honor, I requested
information
from the solicitor's office on the amount of time that Mr. Caffey has served in total. He does have 3 cases before the court, and we're just trying to see how long he has been in custody combined.
All right. The next person on the calendar is Williams Carter.
I'll have it out, and we intend to enter a plea, Your Honor.
I'm sorry?
We intend to enter a plea.
Okay. Next case is Manjeet Jaglin. Manjeet Jaglin.
Your Honor, the state will move for a bench warrant.
He's not here?
He's in custody.
He's in custody. He should be in custody. Jaglin?
Oh, this is the jail. I'm sorry.
Okay, no problem. Yes?
I've spoken with Mr. Jaglin, or attempted to speak with him. He talked to Mr. Lynch. He wouldn't talk to me, so we'll see if he's willing to go forward with the court. I don't think it's a competency issue, but he doesn't appear to be a U.S. citizen, so it may be a language barrier, or he may be not willing to talk to me.
Okay, no problem. All right. And this is Mr. Carter.
This is Mr. Caffey, Your Honor.
Oh, Mr.
And,
Kathy,
Yes,
ma'am.
So we were,
raise your right hand for me, Mr. Kathy. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, Mr. Kathy, you can put your hand down. So you're before the court on 2023 CR 06460 for criminal trespass. You're also before the court on 2023 CR 06470 for criminal trespass. You're also before the court for 2024 CR 6980 for simple assault, obstruction of an officer, and 2 counts of criminal trespass, counts 3 and 4. Mr. Taylor?
Your Honor, again, we're wanting to find out from Solicitor Hagler how long Mr. Caffey has been in custody in total. He has a recommended sentence of 12 months to serve 60 days, which is of the 3, that's the largest sentence requested. So we're wanting to find out if he's been in custody, if he's already served that amount, Your Honor. It'd make an impact on whether we enter a plea today or not.
Can I say something, Your Honor?
No, sir, Mr. Caffey. Just trust Mr. Taylor to speak on your behalf, all right?
Yes, ma'am.
We're counting days at this point. That's all we're looking at right now.
Yes, ma'am.
Okay, thank you.
Your Honor, 1 second, please, while I do that research.
No problem.
It appears it's been in since July 14th. Is that where you were tracking, Mr. Taylor? July 14th, so
That's
a
correct.
little over a month.
For this case, however, he was arrested on May the 11th and also on July 6th. So I wanted to find out how much time he had served in total, please. I don't have access to that. I can only see the date of most recent incarceration. And Your Honor, I believe this might be most appropriate for Ms. Hagler and I to go to a breakout room if you prefer.
No problem.
Okay, thank you, Judge.
Is that breakout room 2? 3?
3, yes, 3.
Give you 2 for 1? Yes. If you don't, you might have a few more days. Thank you, Your Honor. We're ready to proceed with Mr. Caffey's 3 cases.
All right, Mr. Kathy.
Uh-huh.
Mr. Taylor, what does your client plead to the offenses before the court on case 2022 CR 072? I'm sorry, 2023 CR 06460.
Your Honor, my client pleads nolo to that case.
All right. And to 2023 CR 06470.
And for 70, my client pleads nolo to the criminal trespass. He pleads guilty to the theft by shoplifting.
Okay.
And per negotiations with the state, the 3rd case, 2024 CR 06980 is to be no cost.
All right. All right. So, Mr. Caffey, by entering a plea of nolo on the case ending in 06460, by entering a plea of nolo to count 1 and guilty to count 2 on 06470, and case 06980 will be no cost in its entirety. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right. Factual basis and recommendation, please.
Yes, Your Honor. For case ending in 06460 on or about May 11th of 2023, Officer C. Richards, RICHARDS, responded to the incident location, 2684 Rex Road, Ellenwood, Georgia, 30294, Clayton County. Regarding a disturbance. Upon his arrival, he made contact with the complainant, Mubin, M as in Mary, U, B as in boy, EEN, last name Ahmed, AHMED. The complainant advised Officer Richards that the defendant had returned to the gas station after he criminally trespassed from the property for public intoxication on May the 9th of 2023, case number 230-25688. The complainant, Ahmad, said that the defendant had left and returned multiple times. Upon arrival, Officer Richards did observe the defendant leaning on the side of the building. And at that time, Your Honor, the defendant was placed under arrest. The state's offer is going to be 12 months to serve, 60 days. The defendant can get credit for time served, but he has not completed the full 60. So credit for time served, 60 days. Regarding case ending in 06470, on or about July the 6th of 2023, Officer Jordan, JORDAN, Sydney, S as in Sam, IDNEY, responded again to 2684 Rex Road in reference to a disturbance. Upon the officer's arrival, he observed the defendant standing in the parking lot of the business drinking an alcoholic beverage. The officer did recognize the defendant from a previously issued criminal trespass warning for that location. Officer Sydney met with the employee, Sechin, S as in Sam, ACHIN, inside the business. And the victim stated that the defendant stole a beer out of the store and that he was bothering customers. The theft was captured on the body-worn camera. At that time, the defendant was arrested. Your Honor, for this case, count one, 12 months to serve, 60 days, credit for time served, balance suspended. For count two, theft by shoplifting, 12 months probation, 40 hours of community service. The defendant is to not return, I repeat, not return to 2684 Rex Road, which is the Chevron gas station, a fine of $200, and to complete the theft prevention course. And this is to run concurrent.
All right, so Mr. Taylor, is there any possibility in the world that Mr. Caffey is going to be able to complete the terms and conditions of probation?
Your Honor, I've discussed it with him. He asked me what was involved with the theft prevention class. I told him it's not an ongoing class. It's a short, I believe it's 1 or 2 days, and it's not a full day, but it's helped him understand what the impact of a theft
Oh, no, I'm not asking about the content of the class.
Yes.
Is Mr. Caffey working? Does he have the means to pay for? Does he have stable housing? Does he have the ability to get to the classes?
I understand, Your Honor. I will let Mr. Caffey.
Mr. Caffey, be honest with me. Can you get to these classes and can you pay for them?
Yes, ma'am. I receive.
Okay, then if you got the means to do that, why are you stealing beers?
Your Honor, Mr. Caffey has a psychiatric diagnosis, and he receives medication, a monthly shot. I believe in the instances when he doesn't get his shot, he kind of goes off a little bit, not in a violent way, but he does things that are inappropriate and goes up to that Chevron. And I've informed him he cannot go back to that Chevron on Rex Road, that he needs to stay away from it. Absolutely. When he's on his medication, which is when he also receives his Social Security, so he does have some form of income coming in, he's able to both pay for and the fine and the classes. I don't know about his transportation situation.
All right, Mr. Caffey,
Yes.
I don't see you as being a good probation candidate, sir.
Ma'am, I do what it's supposed to be done. I complete my hours of community service, my probation. I be there on time. I pay what I got to pay and get out of there.
All right, this is what I'm going to do. Just because I'm a little dicey on this, I'm going to suspend the $200 fine, and I'll for credit for time served. And is it the intent that he be released today, or that he get credit since the date of lockup?
That he gets credit since I believe it was July 14th.
Okay.
So he has served a little over a month, but that he gets credit for July 14th, credit for time served.
All right. All right. So, Mr. Caffey, I'm going to accept your pleas on the case ending in 06460. Sent you to 12 months to serve 60 days, credit since the date of lockup. The balance on that case will be suspended as long as you do not go back to the Chevron at 2684 Rex Road, Ellenwood, Georgia. You have no contact with Mubin Ahmed. On case two, ending in 06470, on the count one, I'll sentence you to 12 months to serve 60 days, credit since the date of lockup. Balance will be suspended. That will run concurrent with the case 06460. And on the second offense, I'll send you to 12 months probation to do 40 hours of community service. You're not to go back to the Chevron at 2684 Rex Road, Ellenwood, Georgia, in Clayton County. And the fine of $200 is suspended, and you'll take a theft prevention course. All right. And that probation is to start upon your release from jail. Do you understand, Mr. Caffey?
Say it again, man. You were talking to him. Say it again.
I apologize, Your Honor. Just the last part.
The theft prevention course. So, Mr. Caffey, you understand, and I'll suspend the probation supervision fee.
Okay,
All
thank you
right.
so much.
All right, so Mr. Caffey, I'm trying to do as much as I can to make sure that you complete and what you need to complete. But your job is to stay on your medication. Do you understand?
Yes, ma'am. I
All right.
go there every morning to go get my shot. I never miss.
Okay.
I got Jen here also.
All right then. Thank you, sir.
Okay,
Thank you, Your Honor.
thank you.
All right. All right, next. We have Carter, Jaglin, Law, and then Leonard, Robert Lawrence Leonard. It's a petition.
Then I believe we might be ready on Carter.
Okay. Also Kenneth Pack. Patricia Teagle. Jawan Timmons. And Darrell Travis. All right, so do you all need some time to speak to more people and then we can just run through the pleas? What's going on?
I'm sorry, Judge, I was muted. I do have a few announcements there.
All right, go ahead.
And I'm not sure where Mr. Taylor stands, but I have a plea ready for Mr. Law, a plea ready for Mr. Pack. Mr. Timmons has bonded out of jail. I believe Travis is not in custody. Ms. Teagle, we're likely going to resolve that. I just would maybe request a breakout room with yourself and Ms. Hagler. Just the reason being, this is a DUI court recommendation, and I haven't done one of those pleas since I've been back, and I just want to make sure I understand.
Okay.
This.
And you said Timmons and Travis are both OTB?
I know Timmons is OTB, and Travis is not listed as an active inmate, so I believe he is.
Because he's active on my calendar, but this might have been printed.
Well, let me double check with the deputy. Do you have a Travis in custody? Darrell Matthew Travis? I don't believe we have him, but.
Okay. All right. Well, I'm ready for pleas whenever you're ready. So we have a plea ready on Law and a plea on Pack.
I'm sorry, there's already an inmate out here, which would be Mr. Carter. Sorry.
Okay.
Sorry, Judge.
No problem. I'll take them however they come.
Okay. And Mr. Travis is not in custody, Judge. I'm not sure what happened with that calendar, but he is not currently in custody. Looks like he
must have bonded out.
Or we can go non-negotiable, just let the judge tell us what she. I'm not saying you have. You have the choice. You have to tell me.
I'm trying to get back to Kentucky. I can't stay here no more than 3 months. I'm trying to get back home. Also on that floor. I'm gonna do it.
I want, but it has to be your decision. I don't want you to think.
No, it's not. It is my decision. I'm going to go home.
So. And so the judge will show up here in a moment. If the screen goes in and out, if it does, you can look up here and so see, okay?
Mr. Carter?
Yes, ma'am.
All right. Raise your right hands for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right. So, Mr. Carter, you're before the court on 2024 CR 07114 for Williams C. Carter for battery family violence, count 1, battery count 2, simple battery family violence, count 3, and simple battery count 4. Mr. Taylor, what is your client plead to the offenses before the court?
Your Honor, my client's pleading
That
guilty.
was, excuse me, that's not my family.
Hold on, sir. Mr. Taylor's gonna straighten all of that out by the time we finish this, okay?
Hey, I'm sorry.
All right, go ahead, Mr. Taylor.
I was about to say that Mr. Carter is pleading guilty to the first count, and counts 2, 3, and 4 should merge. However, Mr. Carter is indicating that the alleged victim in the case is not a blood relative. However, I do understand that they were both living in the same residence at the time of the incident.
I had to move.
So that would qualify under the battery family violence statute, I believe. You understand?
All right,
You're not
all right. So, Mr. Carter,
have to be family if you're living under the same house.
I was living there and he just moved there.
But he
Counted
moved,
mom
but he
back.
moved. Yeah.
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 Yes, ma'am.
all right, by entering a plea of guilty to count 1, counts 2, 3, and 4 will be no prost. You'll give up the right to have a trial by jury or judge. You give up the right, 2, 3, and 4 will merge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, I do.
All right, factual basis of recommendation, please.
Yes, Your Honor. On or about June 26th of 2024, based on the warrant in the packet, the defendant did intentionally cause physical harm or bodily harm to Lemont, Lemont Carter. Per the warrant, the victim is listed as the defendant's nephew by swinging a wooden cane at the victim and striking him in the face. According to Officer Tyler, Tylor Santos, Santos, this action caused blood risen to the surface of the victim's chin and slight swelling. The defendant said that he and the victim got into a physical altercation after the victim got hit in the face with the cane, which led to another visible injury to the victim's abdomen area with blood risen to the surface. This event occurred at 9843 Byrne, Byrne Drive, Jonesboro, Clayton County, Georgia. Your Honor, at this time, for count 1, the state's recommendation is 12 months to serve, 20 days, balance probated, a fine of $500 for the defendant to attend anger management, 20 hours of community service, and the defendant is to not have any kind of, if the defendant is adamant that the victim is not, related in any way, then the defendant is to have no contact with the victim. Counts 2, 3, and 4 are going to merge.
All right, Mr. Taylor, is this a room and house situation?
It's both people are related to the owner of the house in some manner. I believe that the victim had come there because his mother had passed away. He knew the owner of the house. Mr. Carter was already residing at the house where this occurred. There may be some relationship based on marriage, some extended.
I'm not related to him. I'm the one called the police.
Yes, ma'am, sir.
Because he was threatening me.
But I don't believe the victim was intended to be a long-term resident. Mr. Carter had been residing at the residence and paying rent, was a long-term tenant at the location. I say tenant, but he knows the owner of the residence. Additionally, Your Honor, in addition to the facts as presented, Ms. Hagler, or the police report, the alleged victim in the case advised that he did not want Mr. Carter to go to jail, and there were threats exchanged between both parties. Mr. Carter swung his cane. Mr. Lamont Carter had made verbal threats that he was going to harm Mr. William Carter. And I would like to point out also, Your Honor, that Mr. Carter here is 76 years old.
And I had to move.
And he's had to move. His intention is to move back to Kentucky once he's released from custody, plus takes care of any probation matters if such are required.
Okay, did I hear incorrectly? Because I thought I heard Tyler Santos.
That's the officer.
Oh, okay. So Larry, the other Williams is Larry Williams?
The victim is Lamont Carter.
Lamont Carter, I'm sorry.
Yes.
Hence my confusion. I thought there was some sort of relationship between the
Yeah, I
two.
got you. All right. So is Mr. Carter, the defendant, employed at this time?
I'm disabled. And
Okay.
a little small amount of Ubering when I can, but my car's in the shop. It'll cost about $2,000 to get it out. I relocated, got my stuff in storage. I left furniture. I'm in a bad spot. I'm the one called the police for help. For him.
All right. So I'm going to accept your plea of guilty. Counts 2, 3, and 4 will merge. I'll sentence you to 12 months to serve 20 days. Credit for time served. Balance will be probated for you to pay a fine. The fine will be suspended. You're to do an anchor management course and do 20 hours of community service and have no contact with Lamont Carter. And at the location of 9843 Burn Drive, Clayton County.
I moved to Stockbridge.
Okay.
All right. Thank you,
Your
sir.
Honor,
Yes.
Based on Mr. Carter's financial situation and being in custody,
I'll waive supervision fees.
thank you, Your Honor.
All right.
So am I good to go home today?
All right. So who's next? I think I have Law and Pack. All right. Be right back. Ready when y'all are.
Yeah, go ahead and bring out Law. Judge, deputy's gonna bring out Law. Just for the court, just so the court's aware, Ms. Chang indicated she's ready to go forward for Robert Lawrence Jr. We do intend to stipulate, and we are agreeable to the recommendation from the probation officer on that case.
All right.
But,
All right. So whoever they bring out first, we'll continue in that way.
The day you were arrested, the day you went into custody.
I think it'll be Law and then Leonard, and then we can get Pack taken care of. Okay, sorry. Hey, Mr. Law, go ahead and take a stand here for me if you don't mind. The judge is going up here. I would just kind of look this way towards the camera. She's going to ask you to raise your right hand.
Mr. Law, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. You're before the court on 2024 CR 06998, Khalif Law. Criminal trespass, count 1, false name, address, or date of birth, counts 2, 3, and 4. What does your client plead to the offenses before the court, Mr. Lynch?
Judge, we're asking the court to take no pleas to counts 1 and 2. Counts 3 and 4 would be null pros pursuant to the plea. We will stipulate to a factual basis if the court is so inclined.
Ooh, when you start dipping to the facts, it gets interesting for me. All right, state recommendation in this case. I'm sorry.
Yes, Your Honor. On count 1, the state is offering 12 months to serve, 12 days, balance suspended. The defendant is to stay away from the incident location, which is 5174 Riverdale Road. Make sure I got the proper city. Atlanta, Georgia, 30349. And regarding count 2, 12 months to serve, 12 days, balance suspended, to run concurrent with count 1.
All right. All right, Mr. Law, I'm going to accept your plea of no load to counts 1 and 2. Counts 3 and 4 will be no pros. I'll sentence you on counts 1 and 2 to run concurrent to 12 months to serve 12 days. Credit for time served balance will be suspended as long as you have you do not go back to 5174 Riverdale Road in Atlanta, Clayton County, Georgia, and as long as you have no new violations of the laws of the state of Georgia. Do you understand, Mr. Law?
Yeah.
And Your Honor, for the record, the name of the business is McDonald's.
All right, so do not go back to that McDonald's.
Thank you.
All right, next.
Call your mom when you get out. Okay.
I think if you could bring out Mr. Leonard, Robert Lawrence Leonard Jr. This gentleman, Mr. Law, does not. Yeah, he's probation. I got an appointment ordered here. I don't know. Try to send it back. Scan it later. Just send it. Yeah. Did you already handle Mr. Pack? Mr. Pack is going to come after Mr. Leonard, and the only thing I should have left is Teagle. Let's see if maybe the deputy could bring her out. You say Timmons out to bond. And Daryl Travis. Out to, well, yeah, he's out. He's not. That's why he's out to bond. We've seen Teagle's no, her sister, her daughter. Stand right here.
All right, so this is strange because I have Mr. Leonard before the court for a probation revocation, but I also have a Robert Lawrence Leonard Jr. termination of probation request that was sent.
Oh, I wasn't aware.
Was this a different case?
That was a different case, Your Honor. He was originally sentenced to 36 months of probation, and he's now on his last case, on his last consecutive case.
And so the first case is the one that you're asking me to terminate?
Yes, Your Honor, and that was approved and signed on August the 23rd. I did receive that for the case ending in 04384.
All right, because I'm just trying to find his petition. Hold on just a second. So, Ms. Chang, I have the warrant, I have the request to terminate the previous case, but I don't have his petition.
Your Honor, I just try to resend that petition
Okay, thank you.
to you.
All right, got it. I got it.
Yes, ma'am. Thank you.
Thank you. So this is the State of Georgia versus Robert Lawrence Leonard Jr., 2021 CR 08212. This gentleman was before the court for disorderly conduct on the 7th day of June, 2022, and sentenced to 12 months on probation to run consecutive to case 2021 CR 04384. That case has been 2021 CR 04384 has expired. According to the sentence, the defendant has 8 months and 26 days remaining on this case. This is his third probation hearing. He failed to avoid injurious and vicious habits, and that he tested positive for THC, the metabolite of marijuana, on July 25th of 2024 at the probation office, and he's $242.50 in arrears. All right, Mr. Leonard is represented by Mr. Lynch at the law firm of Lister, Holton, Dennis, and Mr. Lynch, you have indicated that your client wishes to stipulate and agree to the terms and conditions of probation.
That is true, that this recommended sanction from Ms. Chang, and I would just ask the court to accept that. Mr. Leonard, although he has had some issues, I believe the previous case he was a successful probation candidate, so that's, I can go on about Mr. Leonard if your honor is not inclined to accept the recommendation, but if you are, we're prepared to just to stipulate and go forward from there.
All right. So what is the recommendation from the probation office?
Honor, probation recommends that 6 days be revoked, credit for time served since August 21st, 2024. Drug screen each report, and continue to attend 2 AA meetings per week.
All right. So 6 days. All right.
No. Was talking before.
All right, so I have that the defendant shall serve 6 days, have 6 days revoked and shall receive credit since the date of lockup. Defendant shall be released and returned to probation. Defendant shall test for alcohol and substances at each report and shall attend 2 AA meetings per week. Did I miss anything, Ms. Chang?
No, Your Honor, that's correct.
All right. All right, Mr. Leonard, you need this AA. You need AA. You need it. Because you're still dealing with a lot of substances. And even though people don't consider marijuana the same thing, if you're relying on it in a way that you know that there's a possibility you're going to spend time in jail if you test positive, but you're still doing it, then you need it because you're using it as a medication for something. Okay, so continue to do the AA meetings until even after your probation expires, because I believe that is something that could be beneficial to you. Okay. All right, you can go back to the sheriff's office.
Your Honor, may I give him his next appointment?
Oh, go ahead. I'm sorry. Yeah.
Mr. Leonard, if you would report Wednesday, September the 18th at 2 p.m.
Yes, ma'am. Yeah. Yes, ma'am. Thank you, Ms. Chang.
Thank you, Your Honor. Thank you, Mr.
Right,
Lynch.
take care. Thank you, Ms. Chang. If that's your last one, you're free to go at this time.
Thank you, Your Honor.
All right. All right. So I have remaining Jaglin, Pack, and Teagle.
Okay. Pack will be a quick plea if you want to pull out Pack. Mr. Pack's is gonna be a plea. I would say do Pack first. No, but yeah, he's good.
So,
yeah.
So do I sign anything?
No, you. We're not muted.
All right. Mr. Pack.
Yes, Your Honor. Is this Your Honor? How are you doing, Your Honor?
I'm good, Mr. Pack. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, Your Honor.
All right. You're before the court on State of Georgia versus Mr. Kenneth Pack, 2024 CR 07108 for public transit violation and criminal trespass. Mr. Pack, you can put your hand down, sir. You're represented by Mr. Owen Lynch, who's your attorney standing next to you. Mr. Lynch, what does your client plead to the offenses before the court?
No contest, Judge.
All right, and any concerns regarding competency in this case?
I do not, Judge. We've discussed the facts of the case and his rights to a trial versus a plea. And in this context, I believe that he understands those.
All right. So, Mr. Pack, by entering a plea of no to counts 1 and 2, you give up the right to have a trial. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence in your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right, factual basis and recommendation, please.
Yes, Your Honor. On about July 22nd of 2024, Officer Jamar, Jamar Little, was at 1 Atlanta Airport, Atlanta, Georgia, 30230, Clayton County, Georgia, at the Airport MARTA Transit Station, Fairgate, when he saw the defendant walk through the fare gates behind a paying patron. The defendant ignored Officer Little's commands to return out of the paid area. Officer Little approached the defendant on the platform, at which time the defendant stated that he had no money and no MARTA Breeze card. At that time, the defendant was detained and arrested. Your Honor, the state's offer at this time for count 1, 12 months to serve, 35 days, commuted time served, balance suspended. The defendant is to not return to the incident location. And then for count 2, to run concurrent with count 1, 12 months to serve, 35 days, balance suspended.
All right, Mr. Lynch.
That was our understanding. I mean, I would ask that it could be do not return unless he has a valid, ticket to ride MARTA. I don't think the state's intent was to completely ban him from MARTA.
Well, Your Honor, if I may, yes, the defendant does have an active MARTA ride with respect permanent suspension ban that issued on January the 24th of 2023. So he has a permanent suspension, so he cannot return.
I understand.
All right, so Mr. Pack, this means any MARTA bus, any MARTA train, any MARTA station. If you are at any of those places, they're going to arrest you. Do you understand?
Yes, Your Honor.
All right, so I'm going to accept your plea of no to counts 1 and 2. I'll send you to 12 months to serve 35 days, credit for time served. Balance will be suspended, so as long as you do not go on to any MARTA property, ride any MARTA buses, or any MARTA trains. And this is a permanent ban. You understand?
Yes, Your Honor.
All right, count 1 and 2 will run concurrent. It's the same sentence. All right, you can go back with the sheriff's office, sir.
I go home today?
Yes, sir, I believe so.
Thank
if
you.
nothing else is holding you.
Okay.
So we got 2 left, Jacqueline and 2.
He goes, into that first kind of Jacqueline, maybe, and I need your help with this specific help.
So, Judge, for Ms. Teagle, Deputy, is there any way we could bring Ms. Teagle out and have her sit at the table?
All right. So we have Jacqueline and Teagle left. Did we need to continue Jacqueline, or is he going forward?
I think Ms. Taylor wanted to see if he would speak to me more. I did get a few words out of him, but we weren't able to.
Okay, does he have a language issue that we need to account for with an interpreter?
I can't say with 100% certainty. My feeling is that he understands English, but communication.
Well, so we're not sure if it's a language issue or if it's possibly a mental health issue.
All
But,
right.
given the nature of the charge, we'd like to see if we could possibly move the case along, because it would allow for Mr. Jaglin to be released. Is the current recommendation.
Okay, if he's able.
Certainly, Your Honor.
All right.
At least understands this.
All right, so Teagle and Jaglin are the last two.
And Judge, on Teagle, I just kind of wanted to make sure I fully understand the recommendation and the procedure for Ms. Teagle if she does accept the state's.
Yeah, my understanding is we will clarify the sentence, but she won't actually be sentenced until she gets to DUI court.
Right, and so my question is, because this was supposed to happen back in 2020, Judge. She, I believe the case was transferred to Judge Spencer's courtroom for her to do DUI court. Judge Spencer handled DUI court at the time. There's plea paperwork that was signed. Back then, that was during my first stint at Lister and Holt. I did a motion to get her out on bond. She was then released to another county. And then COVID was going on. I know at some point a court date was calendared and she missed that. And now she's back in custody, held on a $30,000 bond. And so my understanding is, or I guess what I need clarification is, if she accepts this recommendation, which is my understanding would be a DUI court sentence, which would, in its consecutive terms of probation. I guess my question is, because she's in custody, when does she, would she be entering a plea before you? Would it go?
No, the plea would be entered before Judge Garrett. So if y'all want me to transfer it to Garrett now in anticipation of a DUI plea, and we can just send him an email that this is coming over for DUI. This is the sentence recommendation. I'm fine with that, but she doesn't get sentenced in front of me. She gets sentenced by the DUI judge.
So then then she would not be released from custody today if that's.
No, she doesn't get released from custody. Because that's what happened the last time. She got released from custody and then we lost track of her for 4 years. And I'm not really feeling real sorry for Ms. Teagle because this is a subsequent DUI. So
no, this is not a subsequent. I apologize, Judge.
For her to be in DUI court, it has to be she's had more than one.
You're correct, Judge. I thought you meant subsequent to the original, but you're right.
No, I'm just saying. So I don't know what happened in the 4 years when she was loaned out to another jail and didn't come back, but she knew she had something pending. It was probably incumbent upon her to say something or let us know what was going on, or that she had a case that she wanted to conclude. Just don't assume that it's gone away, because there's always going to be a warrant out there.
Okay, so for her sake, I want to be able to advise her what's going to happen next in this process. Is she going to get another court date in front of Judge Garrett next week?
Yes. No, I don't know when it's going to be. I know she's going to get one, but I'm not sure when it is, because I don't, once I send it to DUI court, I trust that judge in the process of the evaluators and the administrators in the DUI court. So I just send it over with the recommendation. Now we can put the recommendation on the record and just send it over to DUI, and then they can be sentenced in accordance with the recommendation. But my understanding is she's got to be evaluated and have some other things happen first.
Okay.
That is correct, Judge. Mm-hmm.
Thank you, Ms. Hagler, because, like I said, it's not something I'm conversant with.
So there's no need for her to put anything on the record today as far as whether she's accepting this recommendation or not. It's going to be transferred to Judge Garrett, and then that she'll get a court date there, or I just want to make sure I do everything I need to do.
Okay, so generally, like I said, the recommendation is placed on the record today. Then she'll move to Judge Garrett's courtroom with that recommendation.
Okay. All right. Well, I suppose we're ready to move forward with that.
All right, Ms. Hagler, if you could give me the rec for Ms. Teagle, and then the court will move that case, have it transferred to Judge Garrett.
Yes,
for,
Your Honor.
Inclusion in the DUI court.
Yes, Your Honor. For count 1, DUI less safe, 12 months to serve 47 days, commuted to time served, balance probated, a fine of $600, 240 hours of community service, risk reduction evaluation and treatment, no drugs or alcohol, random drug screens and treatment, and to go to DUI court to attend the MAD victim panel and to attend 2 AA support groups meetings per week.
All right.
And then for count 2, 12 months probation to run consecutive with count 1, a fine of $100, 40 hours of community service, again, no drugs or alcohol, and random treatment and drug screens. And then for count 3, 12 months probation to run consecutive with count 1, no drugs or alcohol, and random treatment and drug screens.
All right, so Ms. Teagle, this is the recommendation that's on the record. Your case is going to be sent to Judge Garrett, who is the DUI court judge, and if you all will send him the email and copy Miss whoever the court administrator is for the DUI program, and then her case will move to Judge Garrett's calendar. DUI less safe, 12 months to serve 47 days, credit for time served. The balance will be probated for a fine in the amount of $600. There's going to be substantial fees attached to that because it's a DUI. 240 hours of community service, a risk reduction course, substance abuse evaluation, and any treatment that may be ordered. You're to have no alcohol or illicit drugs during the course of your probation. You're subject to random screens for alcohol and drugs. You'll attend the DUI court and complete that program. You'll do a MAD impact panel and 2 alcoholics or Narcotics Anonymous class meetings per week on count 2, which will run consecutive to count 1, 12 months probation, $100 fine, 40 hours of community service, no alcohol or illicit drugs, random screens for alcohol and drugs, and you'll on count 3, which will also run consecutive to count 1, you're to do 12 months probation, no alcohol or illicit drugs, random screens, and on counts 2 and 3, you're to continue any of the requirements of the DUI program. All right, so Ms. Teagle, I just ask you to consider while you have this time and while you're in the program that you have a beautiful daughter and granddaughter sitting in the back of the courtroom. And if somebody in your situation was to harm your granddaughter or your daughter because they didn't take seriously the requirements of the DUI program or seriously the need to be sober, just think how you would feel. And don't put anyone else's life or child at risk because you refuse to do what you need to do to maintain your sobriety. Do you understand? All right. So, Ms. Teagle, you all send the emails to the DUI court administrator and Judge Garrett, and that case will be transferred to Judge Garrett's court. All right. Last case is Jacqueline.
Don't understand very well. They are all for students. The owner of the building or no contest it is charged. To tell me that that's what you want to do as you understand what's going on. I can't tell the judge. Yeah, so you got to talk. What language? Hindi? Your Honor, this is Mr. Jaglin, and I was able to sort of communicate. He speaks Sanskrit. So we're not able to communicate effectively with him. He says no English.
All right, Mr. Jaglin, do you speak Hindi?
Andy?
Sanskrit only?
He's indicating yes, Your Honor.
All right, so we'll need a Sanskrit interpreter. All right, so we'll get a Sanskrit interpreter.
Yes, Your Honor, unless the state would consider dismissing the charges against Mr. Jaglin since he's been in custody for 20 days on this criminal trespass with no property damage.
No, only because he was told multiple times to leave and he didn't leave.
All right.
Okay.
Yeah, he might not have understood, but we'll go ahead and get an interpreter for Sanskrit. SANSKRIT, Ms. Val. If we can get a Sanskrit interpreter. Thank you.
John, I do have a question. Do you think that will happen today or?
No, ma'am.
Okay.
Spanish is today. Sanskrit is gonna take us a minute.
Oh, okay. Okay. But that's you said he's been how long in jail, Mr. Taylor? How long has it been in, you said? Since this incident date?
Since the incident date, his intake was on August 8th.
Okay. That's fine. You're that's fine.
All right.
Thank you, Ms. Hagler.
You're welcome, Attorney Taylor.
Thank you. All right, so the court will accept the no pros for the Jaglin case, and that will conclude the jail calendar and the arraignment calendar for August 27th of 2024. Thank you all. I'm signing, so if you have anything that needs signing, I also have an afternoon calendar today, so I'll be signing, but I'll try and sign through that also.
Excellent.
Thank you, Judge.